This is Scott Stork with Polaris Law Group here in St. Charles, Missouri. I'm an estate planning attorney here, and today I want to talk to you a little bit about what probate is. So we have a lot of potential clients and people who become clients come in and they're very confused about what this process they hear about called probate is. So probate is a court proceeding, and it's basically a court proceeding that says if I have property, if I have assets, if I have stuff, and I don't say where it's supposed to go, so I don't, for instance, have a co-owner on the account, if I don't own the property jointly, if I don't do something called beneficiary designations or transfer on death paperwork, if I don't do some estate planning where I've got a trust or something like that that holds this property or becomes the beneficiary of this property or the asset, if I haven't told the probate court, the financial institution in some way where that goes, then it goes to the probate court for a judge to determine where our property goes. Now, there's a lot of issues with that, as you might imagine. Most people don't want to end up in probate court. It's time consuming, it's very expensive, it creates many times a lot of family drama that we don't necessarily want to have happen, and what it does is it puts into the hands of a court where your property should go. Now, they don't just make that up, and the judge isn't just going to determine that of their own free will. They're going to look at Missouri law. And they're going to look at Missouri law or other states, depending on where this probate's at, their law, to say, here's what the law says my property should do. And that's done here in Missouri with Missouri Statute. And for a lot of people, how property transfers, how assets and things that we own transfer in probate upon our death is not what they think it is. So most people have the assumption that if they're married, that all of their assets go to their surviving spouse. And that's not the case many times. So what Missouri statute says is that if you're married and if you have children, that your estate is basically split half and half between your surviving spouse and your kids, and then the spouse gets an extra $20,000 amount off the top before it's split 50-50. Now, as you might imagine, that's not the way most people want things split. They typically want things to go to their spouse if they pass away. And so we can't just leave that to the court because that's absolutely not going to be how things pass. There are some people who don't want certain of their children maybe to inherit, or they don't want other family members to inherit. And so if we leave it to the court is bound to just look and see what Missouri's statute says. So they don't have a lot of discretion there. If somebody who passes away doesn't want a certain family member to get it, well, there's no evidence or there's nothing that the court can hear from one kid that says, well, I know dad didn't want the other kid to have it. That's not how it works. They are going to give things pursuant to what the law says. And so that's a big issue for most people. They'd rather have control about where their property goes rather than leaving it up to just what the law says. Another issue, as I said, is that it's very time consuming. Typically, the quickest you can get out of probate court is going to be at least 6.5 months, and that's at the very minimum. Many times we have probates that take much longer than that. So, rather than things being kind of transferred in an orderly fashion and in a fashion that's not going to take potentially over a year and things like that, being in probate court's not the way to go. The other thing is that it's very expensive. So Missouri sets minimum amounts that attorneys, that executors of estates, things like that, should be paid. And it is kind of a percentage based on the size of the probate estate itself. So for instance, if it's a $500 estate, well, Missouri is going to say, here's the percentage of that $500 or $500,000 estate that's going to be paid to the attorney, to the executor potentially, to other professionals. And by the way, here's all the other fees that the court charges to get things through the probate process. And so as you might imagine, it is not a fun place to be. The last issue is that typically people can't go through probate without hiring a lawyer. And so That can be great for lawyers. That's business for them, but it's not necessarily great for your family for a multitude of reasons, including also the fact that they're going to have extra expenses again for that attorney and things like that. So people think, well, I'll just go through and maybe get stuff through probate myself. They absolutely can't do that typically. So all sorts of issues that come up with probate court. Most people want to have control about where things go. They want to make sure it goes to their loved ones in the way that they want to do that. Typically, we see that things don't end up matching what people's actual intentions are. We want to make sure that there's family harmony. Typically, we want to make sure that things are going to kids in the right way. And again, left to the probate court, it's absolutely not going to do that. It's going to be just basically a lump sum out, a check to the children, the family, etc. No protections, no instructions, not necessarily the cleanest way to send things. So don't want to be there. The best way to deal with things is to plan ahead. Make sure that you work with an estate planning attorney to get your plan done, whatever that might look at, so that it meets your goals, so that it makes an orderly transition to your kids, so that they've got potential help later and they're not left to fend for themselves. So again, Scott Stork with Polaris Law Group. If you've got questions, if you would like to talk more about planning, please let us know. Our phone number is 636-757-3850. You can find us at polarisplans.com. And I hope this was educational, and have a great day. Thank you.